You know what they could do? They could put a room in the White House where he could hold press conferences and make public statements like to the entire country right in the White House. If they did that, I think it would fix it. Already, before we even got to the introduction here, this is all wrong.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So a new weird lawsuit has been filed by Eric Estavillo against Twitter and Alexandria Ocasio-Cortez, the U.S. representative, and Ilhan Omar, also a U.S. congressional representative. And you might remember Eric Estavillo from the case where he sued Twitch. He had sued Twitch because he had trouble controlling his desires and urges when he was scrolling through Twitch's thumbnails and available live streams. And so I'll let this AFK Gaming headline tell it for me. The lawsuit that he filed was dismissed, and rightly so, because I don't think you can't sue Twitch because you have uncontrollable urges and are addicted and go on to Twitch and have trouble with your addiction. That's just the nature of the internet. If you have a gambling problem, you have to avoid gambling sites. If you have a attraction problem, then maybe avoid sites that exacerbate your attraction. But it's not the site's fault. You know, if there are attractive women on Twitch, okay, well, just don't click on their videos. It's not Twitch's fault that you have to look at that. Don't know how else to say that. That's how his case got dismissed there. He's doing it again, though, and let's go over this lawsuit and we'll see what we make of it. So this is going to be my reaction to his lawsuit. So he says, the plaintiff immensely objects, condemns, and seeks restitution for the unsolicited and overbearing pain and suffering he has experienced after the sitting president, Donald J. Trump's Twitter account was banned, as well as seeking justice for the 88.7 million other followers who are now suffering adverse mental effects as they too were heavily invested in his account. I think I have some problems with the language there, and also there's going to be a standing issue. Right away I can see a standing issue that he doesn't have any standing to seek justice for 88.7 million other followers, unless he's going to be a class representative, which has a whole bunch of requirements under Federal Rule Civil Procedure. Furthermore, Twitter consistently promotes Eastern communist philosophies through its platform on a daily basis, which is consistently being perpetuated by Alexandria Ocasio-Cortez, Ilhan Omar, and the Twitter platform through its enabling and endorsing of such socialist propaganda. Isn't the Twitter feed based on who you follow? So either you're searching for hashtags or following issues, or you're following accounts. So if he doesn't want to see what AOC and Ilhan Omar say, don't follow their account. You can even block them and then you don't see it at all, right? This is unconstitutional when taken as a whole in regard to the limiting of certain free speech, while allowing other controversial speech to go unchecked. Once again, this misunderstands the whole free speech issue. I know we've said this a million times before, but the First Amendment prohibits the government from restricting speech. Twitter is not the government, is not a government actor, also known as the state actor doctrine. So Twitter is not subject to free speech rules. The only relationship that you have with Twitter would be your contract, the terms of service, privacy policy, and any other written agreement that you've made with Twitter. They have to follow that, but without even reading it, I'm pretty sure it says, we don't really owe you anything, and you use the service according to our terms. Given that Twitter is now acting as a publisher and not a host of such content, this misunderstands the publisher platform distinction in CDA 230, the CDA 230 law is just making clear an already existing legal relationship that you are not vicariously liable for someone else's content that you host on your site until you reach a level of knowledge and overt action. CDA 230 doesn't change that too much. It just makes it explicit. But because of the language, there's been this huge misunderstanding that means that someone crosses the line into becoming a liable publisher as opposed to a platform host. And there is a line, but it's not there. Like, there's a whole legal definition behind that. Twitter is now officially operating as a virtual company town where all voices are heard and political ideas exchanged. This should occur on its platform without fear of banishment from such a publisher as Twitter, and now they should be held accountable to such a standard as previous US case law demonstrates that they are now operating as a virtual company town. No, and I don't have to just say that. There's a whole case, Marsh v. Alabama. We covered it. The standard for operating a company town is a lot different than just hosting free speech on your website. So Twitter can host speech on its website without crossing the line into providing water, sewage, roads, regulations on building standards, taxes, and other governmental functions. You must cross the line into operating an actual town, but be a privately owned company. That does not mean that the town suddenly becomes owned by some public government corporation. Many towns are private corporations, but because they're being operated as towns, that makes them state or government actors. We don't have the same relationship here with Twitter. Twitter is simply hosting user-generated content. That user-generated content is speech, protected by the First Amendment. But again, that First Amendment protects the government from saying what Leonard French can and can't say on Twitter. And we went over this in a video last week about the incitement or Brandenburg line, another bubble. And the Brandenburg line is that fire in a crowded theater line. You can say fire in a crowded theater, but it's the context that matters. Does it incite imminent lawless action? That is the standard for the Brandenburg line. So shouting fire in a crowded theater and causing, a disturbance, the disturbance is the imminent lawless action. Whereas if you're an actor on the stage and you shout fire, well, the context says that you're the actor on the stage who's probably saying a line in a play or a musical or something. So that's not the same thing. You have to look further than just, did you put speech on Twitter? That doesn't mean it's a virtual company town. I get the analogy, sure, like these places are places where people speak. But that doesn't mean that every place someone speaks is a virtual company town. If I go to my local private bar and I start shouting to the bar about my thoughts on something, that doesn't mean the bar is suddenly converted into a virtual company town. Likewise, if the bar hosts a open mic night and allows people to go up to the mic and speak, that doesn't mean that they can't place any limits on it or that they've automatically become a government actor. These are not the same thing. Twitter is a private company. It being publicly held, as in shares are sold on the stock market, that doesn't change anything. That doesn't mean it's not a private company. It's just a private company that's publicly traded. Like, its shares are publicly traded. That's what that means. So already, before we even got to the introduction here, this is all wrong. So he goes on, this is an action to ensure Twitter acts as a host and not take on a role as publisher of socialist communist propaganda, and to prevent them from targeting certain online personalities and silencing their freedom of speech occurring in a virtual company town. Rather than silencing a political argument as a whole from both sides of the political spectrum, Twitter instead commits egregious and aggressive censorship, which is damaging to the plaintiff's political foundational beliefs, his psyche, and his mental well-being. The standard for showing mental damage is super, super high, and I don't think they're going to meet that here, so pay attention for that too. Also, damaging the plaintiff's political beliefs are their beliefs so weak that Twitter can damage them? First off, that's not legally recognizable or legally cognizable damage. And second, like, really, if your beliefs are that fragile, that's not Twitter's fault. Ironically, the plaintiff is a registered Democrat and ran for Congress the previous year, but finds the behavior by these particular two Democrats, Alexandria Ocasio-Cortez and Ilhan Omar, especially egregious. Okay, so wait, what are they doing? Let's pay attention for that. And finds Twitter complicit in such propaganda, particularly disturbing as they are shaping young minds. Twitter has not once flagged their accounts, I guess AOC and Ilhan Omar, for such communist propaganda. I don't know that there's a violation by posting your communist propaganda, although I also don't think that AOC or Ilhan Omar are communists, whatever that means anyway. I mean, if we're going to go into socialism, like, insurance is socialist, but I don't see companies railing against insurance as it being socialist. I see companies railing against insurance as being a scam. Love Louis Rossman's videos on that. But I don't see people saying, like, car insurance is socialist, we shouldn't have it. But having instead chosen to permanently ban the sitting president Donald J. Trump's Twitter account this past week, which the plaintiff heavily relied on for a fair and balanced viewpoint on all political discussions of the day, which occurs on Twitter and its reliably unbiased online platform. Maybe Mr. Estavillo doesn't realize that Trump has his own press corps, like his own he has a press room in the White House. He can speak anytime he wants to the press and to the public. I believe there's even a presidential text messaging system built into your phone where the president can address you by your phone if he wanted to. I'm actually surprised he hasn't done that. Twitter is essentially acting as a publisher by censoring certain content instead of acting as a host in accordance to such content. No mention of the terms of service of the agreement. While Twitter will inevitably rely on Section 230, and the other laws. It's not just Section 230. There's a whole law for vicarious liability and respondeat superior. As a political shield to further their socialist agenda, they should not be protected in this instance because they are acting as a publisher and not a host. Twitter falls under the company town exception. That is a conclusion. We need to see your analysis. You need to state a claim, plausible claim for relief that a court can legally grant. And there's no claim for relief that a court can grant here, so we'll go over the motion to dismiss that's inevitably coming. Twitter falls under the company town exception in regards to its limiting of certain free speech, as ruled in the Supreme Court's decision in Marsh v. Alabama, which I've discussed before. That decision ruled that a state or private entity such as Twitter should be held liable. It did not rule that Twitter should be held liable, by the way, which is what he just said. If they prevent the distribution of such free speech that may be useful to the public, Twitter now operates as a virtual company town where the court noted that the rights of citizens under the Bill of Rights occupy a preferred position. Accordingly, the court held that the property rights of a private entity are not sufficient to justify the restriction of a community of citizens' fundamental rights and liberties. Again, there was a lot more to the company town doctrine than we just hosted someone's speech. Twitter is a virtual company town, he concludes, without a doubt, and must be held to the same standard and not interfere with political discourse, especially that of the sitting president. This position was firmly affirmed in Pruneyard Shopping Center v. Robbins, which is now the gold standard for freedom of speech which occurs on private entities' property, or, as in this case, a private virtual platform acting as a company town. Again, that's a 1980 case, so Twitter was not around. Let's take a look at what Pruneyard Shopping Center v. Robbins says. The underlying dispute began in 1975 when a group of high school students set up a table at Pruneyard Shopping Center, California, to seek signatures. The shopping center security guards asked them to leave because they had not obtained permission from the shopping center's owners. The students sued the shopping center for violating the rights of their First Amendment, as well as the right to petition the government. The Supreme Court reversed the Superior Court and ruled in favor of the students, the state Supreme Court held that the state's constitutional rights to freedom of speech and petition for redress of grievances operated independently and were unaffected by the interpretation of the federal First Amendment. The shopping center's owner petitioned the U.S. Supreme Court, which unanimously upheld the California Supreme Court. Under the California Constitution, individuals may peacefully exercise their right to free speech in parts of private shopping centers regularly held open to the public, subject to reasonable regulations adopted by the shopping centers. Under the U.S. Constitution, states can provide their citizens with broader rights in their constitutions than under the federal Constitution, so long as those rights do not infringe on any federal constitutional rights. So in Pruneyard, the California Constitution did allow for some rights of free speech to be visited against private entities. This holding was possible because California's Constitution contains an affirmative right of free speech, which has been liberally construed by the Supreme Court of California, while the federal Constitution's First Amendment contains only a negative command to Congress to not abridge the freedom of speech. This distinction was significant because the U.S. Supreme Court had already held that under the federal First Amendment, there is no implied right of free speech within a private shopping center. The Pruneyard case, therefore, raised a question of whether an implied right of free speech could arise under a state constitution without conflicting with the federal Constitution. In answering yes to that question, the court rejected the shopping center's argument that California's broader free speech right amounted to a taking, which is a Fifth Amendment taking of private property for public benefit, of the shopping center under federal constitutional law. Because of the Pruneyard case, people who visit shopping centers in California may regularly encounter people seeking money or attention for various causes, including charitable solicitations, qualifying petitions for amendments to the state constitution, voter registration drives, and sometimes begging. In turn, many shopping centers have posted signs to explain that they do not endorse the views of people exercising the right to free speech, and that if patrons do not give them money, the speakers will go away. And there's always the right of the government, and now in Pruneyard, private California entities, to place reasonable limits on the free speech. Like, you might have to get a permit. The permits have to be given, but the permit may say you're only allowed to do your thing here at a specific place and time and in a specific manner. So maybe you can't take over the mall and walk around with a 10,000 strong crew and make everybody shopping completely miserable. But maybe you can have this one 6x10 area to set up a table and some signs and hand out pamphlets. So those are the restrictions that are allowed on speech. And so apparently we have learned through Eric Estavillo here, thank you very much, Mr. Estavillo, that California does have a private right to speech. Now, let's translate that to Twitter. Does that mean that Twitter has to host all speech with no conditions whatsoever? No, of course not. Nor is the Twitter platform, or even if it is a publisher, because it's technically both, and again, the devil's in the details, and you've got to look at the context, nor is Twitter acting like a place for other commerce. It is a speech platform. It is a content host. A shopping center is not a content host. A shopping center is a place for businesses to sell their wares, for commercial activity there. So it's not quite a one-to-one analogy. And so how would you analogize Pruneyard Shopping Center to Twitter? Twitter would have to give people a way to open an account and say stuff on their platform and not unfairly limit it if the California Constitution applies to Twitter, which I'm assuming the Constitution applies to Twitter, but if that private speech part applies to Twitter, and I don't see how it does, but even if it did, how did they violate Mr. Estavillo's rights? Was he denied his speech without any sort of cause or reason? No. He's saying that he's damaged because Donald Trump got banned after Donald Trump violated their rules. So Pruneyard actually says that Twitter is doing exactly what it's allowed to do, in my opinion. So he goes into jurisdiction, and I don't really care. And he goes into parties, and I don't really care. And he's copied Alexandria's Ocasio-Cortez directly from Wikipedia, it looks like. And so when he goes into Knight First Amendment Institute v. Trump, was a lawsuit filed where plaintiffs were a group of Twitter users blocked by Trump. And of course, because Trump uses his Twitter account, or I guess used his Twitter account for government edicts, for talking to his constituents, that gave his account protections in the reverse direction. He was not allowed to block people from viewing his account because the government cannot pick and choose who the government talks to. The government has to make its edicts available to all of its constituents. And so now you're going to see, I think you're going to see Eric Estavillo try to twist that in a different direction. They alleged that his account constitutes a public forum and that blocking access to it is a violation of their First Amendment rights. The lawsuit also names White House press secretary, etc. Though the Knight Institute's Twitter account had not been blocked by Trump, they were standing in for the people who had been blocked. He just named all the people. The lawsuit argues that they and other followers are now deprived of their right to read the speech of the dissenters who have been blocked. The complaint and subsequent ruling states that posts to the real Donald Trump account are official statements and ruled that Twitter was President Donald Trump's primary form of communication. Well, I don't know if it was primary, it was one of his primary, sure. This precedent assures that Twitter, in regards to the president's account, in most respects should be viewed as a public forum, and company town was decided in this case. No. He started the state with the facts of the case and then he immediately made a conclusion. He skipped over any analysis whatsoever. As for the plaintiff in this case, Mr. Estavillo suffers from a myriad of health issues, including the inability to grammatically correctly use myriad, including but not limited to clinical depression, obsessive compulsive disorder, panic disorder, agoraphobia, and Crohn's disease. What does Crohn's have to do with anything? I get how maybe some other mental disorders, but Crohn's is not a mental disorder. Due to these health issues, he has no friends and rarely leaves the house except for Inflectra infusions for his Crohn's disease, and heavily relies on Twitter for political discourse, debates, arguments, and relies on the fairness of hearing all sides of a political story. Needs to hear voices from a full political spectrum on Twitter to make informed decisions. But doesn't he say that AOC and Ilhan Omar, he doesn't want them to be on Twitter, but he wants to hear full spectrum of political statements? Especially before voting in election. He also uses Twitch as a means of entertainment, because that's, has nothing to do with this case. But now we're going to go into Twitch and the popularity of Twitch and Twitch streams and AOC and Ilhan Omar on Twitch. And now she constantly talks about Twitter, apparently. And streamers were playing with, so he goes into the Among Us streams with AOC and Omar and Hassan. And he streams on Twitch, and he said America deserved 9/11 because that means anything. Other inflammatory rhetoric, Twitch streams, and then finally we're back to Twitter. The ACLU pointed out and warned that the banning of the sitting president's Twitter account is dangerous, especially since it will result in unchecked power of Twitter and such people as AOC and Omar. Make the connection there. Why is it dangerous to ban the president's Twitter, but results in unchecked power of AOC and Omar? They haven't done anything to violate Twitter's terms of service. He says, AOC has continued to affect the plaintiff's political foundational beliefs, his psyche, and so that would be, by the way, grammatically correctly, this would be affect, AFFECT, and mental well-being as she promotes communism, socialism, and unjust censorship of the sitting president. She says this is policy head for something. By the way, they lobby both parties for austerity, and so he's calling out a retweet about a policy matter and some other things that these are really bad copies, and Ilhan Omar talking about Israel. And then he cites to the ACLU saying that the ACLU has had some influence on court decisions, probably a lot of influence on court decisions. But I don't know that that makes them an authority to be cited in his case here. Like, how does that... It doesn't make something more likely to be true or less likely to be true, so it's not relevant. Twitter is guilty for allowing rhetoric to go unchecked while punishing opposing views and now needs to be addressed and redressed by the U.S. court system in the best interest of American followers of the president's Twitter account. So then we do have a claim for relief that Twitter be labeled a virtual company town and have to immediately reinstate Donald J. Trump's Twitter account and pay reparations in the form of punitive damages in the amount of $88.7 million for each follower. $88.7 million for each follower. I'm assuming he means $1 for each of the 88.7 million, but I think he also says here $88.7 million for each follower, because each follower was without a doubt emotionally and mentally damaged as a result of the president's ban. The plaintiff can attest and is willing to testify in court to the pain and suffering on how the banning of the president's Twitter account has affected his already damaged and fragile mental health. And then he goes into the Americans with Disabilities Act should protect him. But where was the statement about the Americans with Disabilities Act up above? You need a short, plain statement of the facts and a prayer for relief and jurisdiction. So a prayer for relief, great, but relief from an Americans with Disabilities Act claim. But where was the Americans with Disabilities Act short, plain statement of the facts? From such egregious behavior occurring on the part of Twitter and its leftist socialist agenda, as the company has no doubt mentally harmed all of the sitting president's followers. Injunctive and immediate cancellation of Ocasio-Cortez's Twitter account because it has violated Twitter's terms of service by targeting a mass flagging banning campaign of all political viewpoints she disagrees with. What? Where was a short, plain statement of the facts showing a mass flagging banning campaign of all political viewpoints she disagrees with? No one has brought a claim that says she has banned them and that she uses her Twitter account in a similar way to the President Knight First Amendment Institute case. I could see it. I could see the claim that if she bans somebody, yes, they probably need to be unbanned under the Knight First Amendment Institute case. But I didn't see anywhere where it said that she had banned somebody. And then he goes into an IE, which does not mean, for example, the president's Twitter account by forcing Google Play in the App Store to ban the conservative Parler app, but AOC made sure he has nowhere else to voice his First Amendment rights to free speech. But AOC made sure he has nowhere else to voice his First Amendment. You know what they could do? They could put a room in the White House where he could hold press conferences and make public statements like to the entire country right in the White House. If they did that, I think it would fix it. Injunctive and immediate cancellation of Ilhan Omar's Twitter account as it violates the Twitter terms of service. So a note about standing here. If Ilhan Omar's Twitter account violates Twitter's terms of service, that is an issue between Ilhan Omar and Twitter. Anybody who tries to assert someone else's rights is going to have a standing issue because they're not the one that has the right to stand in. There's a whole series of requirements for standing that we can go over. I think we've gone over them several times. But basically, Mr. Estavillo would have to show some kind of concrete injury he has suffered, and his account wasn't banned, his account wasn't affected. He hasn't been affected in any way by Ilhan Omar or Alexandria Ocasio-Cortez's Twitter account. He can choose to follow or unfollow or block or mute their account at any time. He does not have to watch or listen or agree or disagree. He can just not. It's sort of like if they're playing a song on the radio that you don't like, you don't sue the radio station for a violation of your ears. You just change the station. I mean, this is super simple stuff here. She targeted the president's Twitter account and pressured Google Play and App Store to ban the conservative Parler app. Well, wouldn't pressure, even pressure coming from a senator or congressman or woman, congressperson, wouldn't that be their free speech right as well? They could make a law, and if they made a law, that would be legislative action, and that might violate free speech. But if they say, we think you should ban them, that doesn't mean that they're a government actor. That at that point, they're a person who works for the government, they're a representative, and certainly that might carry a lot of weight. But that doesn't mean they're a government actor. I think didn't we see another lawsuit where someone is trying to say that Adam Schiff? Yeah, I have another one of these someplace. I'll make a link to it if I recall what it was. And then that's the end of his complaint. So punitive damages without assessing any actual damages. That's a nice, interesting thing there. No mention of the Twitter terms of service other than saying that other people violated it, so he somehow has a right to sue. No understanding of Section 230. No understanding of standing. And I don't really see how this could possibly go anywhere other than a motion to dismiss. Because on a motion to dismiss standard, the plaintiff will have to have made a short, plain statement of the facts and a claim for relief. That all of this has to raise into the realm of plausibility that there is an amount of damage that has been done that is remediable by a court ruling. And there is no court ruling that you could make to Twitter that would fix what Mr. Estavillo complains of, let alone that there is no law on which a court could rely to do so. In fact, quite the opposite. If Mr. Estavillo could simply tell the government to tell Twitter to do certain free speech things, that would violate Twitter's free speech. So it's a complete misunderstanding of free speech, CDA 230, standing, and contractual principles. So let me know what you think about that ridiculous lawsuit in the comments below. I expect that if he has paid for the lawsuit, the $400 to file the federal complaint, then Twitter will have to respond with a basic motion to dismiss, and the case will get dismissed. If he has not paid the $400 and he's done the informal pauperous thing, then the court can dismiss it on its own. Let me see if I can find that out real quick here. Oh, look, he has filed an informal pauperous motion, which means the court will dismiss it on its own. I doubt Twitter will even have to respond to this. I doubt that AOC or Ilhan Omar will even have to respond to it. By filing the lawsuit informal pauperous, you subject yourself to the court's evaluation as to whether the lawsuit is frivolous without the defendant having to file a motion to dismiss. So I expect that is the last that we will see of Eric Estavillo versus Twitter. This particular case, I'm sure we'll see more of Mr. Estavillo. And I'm not trying to give a platform to Mr. Estavillo so much as educate people on what the standards are for these things. I'm sure that if Mr. Estavillo brought this case to an attorney, he would not get very far because there is no claim here. He even mentioned an Americans with Disabilities Act claim, but didn't support it in any way with any facts. I think what he means is, under the Americans with Disabilities Act, places of public accommodation have to accommodate people's disabilities, and those places are places of lodging, recreation, transportation, education, dining, stores, care providers, places of public display. That is physical places. And we saw this in the Domino's case, where this was extended to a website, but only because the website governed access to a place of physical accommodation, the Domino's store. So because you would order a pizza and then go pick it up, you had to have Disabilities Act accommodations in the website as well. Twitter does not have a physical location. You do not go to the Twitter store. So the Americans with Disabilities Act, I don't think that at least Title III doesn't apply to Twitter in any way. Anyway, let me know what you think of that ridiculous lawsuit in the comments below.
Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of January: Joe Tyson, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, HotGrillsInYourArea, Torpedan, Brandyn Abel, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, Earthbound Star, Nathan McCarty, and Awful Asses with Lemon Fresh. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.